Swayam Prabha. Digital India. Educated India.
Welcome friends, we will continue our discussion in this course of Law of Torts, Consumer Protection and Motor Vehicles. Today in the fourth lecture, we will discuss about the general defences. Now what is meant by general defence? Yesterday when we were discussing in our second lecture the constituents of torts, I mentioned that the first constituent is that there has to be a wrongful act. Now the question is when an act is wrongful, and in that elaboration I said that an act is wrongful when it is done without any justification. So therefore, if a act by a person affects some other person and may also cause some loss, damage or injury, but if it is justified by some legal reason, then that will not be a wrongful act. So therefore, if an act which causes injury or harm in civil law is justified by some defence, we usually not consider it as a wrongful act. Now when we come to this justification, they are categorized in two parts. The first category is called the general defences. General means that these are some justifications which can be broadly adopted by the defendant in case of any torts. Largely there is no particular type of torts where this will apply and not apply. Usually these are defences based on the facts and circumstances, can be adopted by the defendant in any tort. That is why they are called general. In addition, there is another category which is called specific defences. So with reference to specific torts, those specific defences can be pleaded. For example, of a specific defence, if we say in defamation, truth is a complete defence. The statement which is claimed to be defamatory is factual or truth, and therefore there is no defamation if there is a factual or truth. Now that defence will not be applicable for negligence or trespass or nuisance. It is only limited to the tort of defamation. Similarly, in negligence there is a defence which is called contributory negligence. Contributory negligence means that when you are saying that I have a harm or a loss has been caused to me due to the negligent act of the defendant. Now if the defendant can show that there is some negligence also on your part, if you had not committed that negligence, then probably this whole incident may have been avoided or could have been avoided. So then that your fault is also cannot be completely waived. So it is called the defence of contributory negligence. Now contributory negligence again cannot be pleaded for defamation, cannot be pleaded for trespass, cannot be pleaded for negligence. But the list of defences that we will discuss now in this lecture, they can be usually pleaded almost in all types of torts. However, there are some limitations, but largely they can be pleaded in almost all torts, and that is why they are called general or normal defences. Okay. So these are some general defences that we will discuss today. Starting with the first one, volenti non fit injuria, that if a injury is caused by voluntarily consenting to take part in a particular dangerous event or something where there is a risk and voluntarily incurring risk, and if the injury is caused, then the defendant is not liable. It is called the consent defence or volenti non fit injuria. Then the second one is plaintiff is a wrongdoer. So if the plaintiff has also contributed in the wrong, like this is not contributory negligence. Plaintiff is a wrongdoer means that plaintiff has also taken part in the wrong. But contributory negligence is different. We will have a full lecture on contributory negligence. This plaintiff as a wrongdoer is not contributory negligence. Plaintiff as a wrongdoer is a separate defense. It is an individual defense, usually coming under the head of general defenses. For example, if I have pleaded a case of personal injury due to trespass to body, okay, somebody has, or an assault, somebody has assaulted me. Now that person says that this is because he was he was first threatening me, he was trying to hit me, so I tried to plead as my under the right of private defense. So I hit him on the right of private defense. So there plaintiff's attempt can be considered as a plaintiff as a wrongdoer. So that's plaintiff as a wrongdoer. Then inevitable accidents. Inevitable accidents are where accidents are caused where it is outside the such capabilities of human to prevent it, but it is obviously caused due to some human act, but it is outside the scope of the human to prevent it. That is called inevitable accident. Then act of God, which is also usually falling within the category of inevitable accident in some commentaries, but separately it can be also stated. Act of God means that when the wrong is caused without any intervention or any act or which is outside the control of human agency. So loss caused due to flood, loss caused due to earthquake. Now you often say that it is an act of God, so we can't help. Of course, you remember the famous case of Oh My God 1. Now yesterday I discussed about the Oh My God 2 case. The Oh My God 1 case where Paresh Rawal pleaded to the court for compensation for his shop which was broken due to earthquake, and he pleaded that the God should pay compensation because it is an act of God. Now why act of God here became important? Because the insurance company where he has insured his house, then insure the house or his property against all sort of acts, however had an exception clause which said that if the loss or damage is caused due to act of God, the insurance company is not going to compensate or pay. Now therefore he said that if the insurance company is not paying, then I have to ask for the God to pay my compensation. So hence I have come to this court. So act of God, which is also called in Latin vis major. Then private defense. Private defense is everybody has a right to protect his own property or his own self. So if somebody has acted in a matter of intervening his somebody's personal body or his property, then in case of protecting that, if some injury is caused, that will come under the defense of private defense. Then necessity. Small wrong could not be avoided for causing a loss or huge damage. For example, there was a fire that had broken and there were a chain of houses made of straw, and in order to stop or eliminate the source of fire, the house number 5 was broken down, so that the 6, 7, 8, 9, 10, 11, 12 like that houses are safe. Only 1, 2, 3 were burned by the fire incident, and the 4th was pulled down. Now the owner of the 4th, if he pleads for compensation, then in that case this defense of necessity can be pleaded, that wrong was caused due to saving the larger good. And last is mistake. Although mistake is usually not actually accepted as a defense, but in trivial cases mistake of fact. Of course, mistake is law is not a defense. There is a concept called ignorantia juris no excusa, that is, ignorance of law is not an excuse. However, mistake of fact in some limited cases can be considered as a defense. So these are the defenses that we are going to discuss over the period of time in the next about 50 odd minutes. So we will start with the voluntary non-fit injury, or what is called the consent defense. Honorable High Court of Madras had an opportunity in the case of Branch Manager National Insurance versus Aguilian in 2011 to state what is this consent defense and what is its scope and ambit. And I quote the High Court's opinion. It says that harm suffered voluntarily does not constitute a legal injury and is not actionable. This principle is embodied in the maxim volenti non fit injuria, where the sufferer is willing no injury is done. A man cannot complain of harm to a chance of which he has exposed himself with the knowledge and of his free will. It is also stated that one who has invited or assented to an act being done towards him cannot, when he suffers from it, complain of it as a wrong. Now, what the court is saying can be explained through a simple illustration. Now, there is a game called fencing. It's a full body contact game, and there is all possibility, or say karate, boxing, taekwondo, other types of martial arts which are full body contact game, even any sport. Now, there is all possibility that with all the protective gears and all the kind of necessary rules, still there can be, in very limited but unfortunate cases, some injury or death to the players or the sportsmen, and this is not rare. Even a game which is obviously not so unsafe or not treated as such threatening, like boxing or karate, cricket, there also we have seen in past that cricketers have died on field because of injury incurred, or football. Now, in these cases, now they cannot claim compensation simply because that when they participated in the game, there is a possibility that there is a risk involved in it. They could be injured, or those injuries can lead to even their death. Now, knowing fully, because of the love for the sports, or because of the glory that carry in the sports, they have participated. Now, after participating, if they have unfortunately been victim of unfortunate incident which has caused bodily injury or death, they cannot complain. The best example is the Australian cricketer who was fielding in Silly Point, got hit by a ball in a close range, and though he was wearing a helmet, but still he could not survive and died. Similarly, there was another incident of an Australian cricketer who was hit by a ball, a bouncer, and though he was wearing a helmet, he suffered an injury to which he succumbed and he died. Now, in those cases, he cannot plead for compensation or wrong on the part of the bowler or the batsman, because it's a voluntarily incurred risk. Now, say for example, if you are a fire person and you have you are working in such a profession where risk is there. Now, knowingly you have participated in that, knowingly you have taken. Now, if there is an injury in case of conducting your job, then you cannot ask for compensation because you knew it very well. This has been explained by very simple and candid language by the High Court of Madras, saying that harm suffered voluntarily does not constitute a legal injury and is not actionable. So, harm which is suffered voluntarily cannot constitute a legal injury and no action can be claimed for that. Now, where this maxim applies? This maxim applies for trespassers, right. So, you have given a notice on the wall that beware of some fences or some electric wires or some dangerous animal, and knowing that also somebody illegally wants to enter your property, then you are protected, because that person, very well knowing that there is some kind of a risk involved, still undertook the risk. So, a trespasser having knowledge that there are spring guns in a wood, although he would be ignorant of the particular spot. So, you have said spring guns have been placed to secure the property, and knowing very well the notice being very clearly put on a very in a place where you can easily find it, anyone can easily find it, still somebody enters that property. But where the maxim does not apply? The maxim does not apply is when a person who climbs over a wall in pursuit of a stray fowl is shot by a spring gun set without notice and cannot recover damages. Now, if the same spring gun is put on in a normal house where there is it can be accepted that it is a defense property, or it's a property where some industrial setup is there which is hazardous. Then to protect anybody illegally trespassing or entering, some kind of higher measures are acceptable. But in a normal residential scenario, if you put spring guns on the wall and you also don't put any notice, then a small boy, if he enters into your premise, though he is a trespasser at the beginning, to catch a stray fowl and gets injured, you cannot claim. And you cannot claim simply because that your act is not that you have a spring gun, it is not notified anywhere. Third is the application of the maxim. It is based upon the competence of decision making capacity of a person. So, what is the objective or what is the principle behind this maxim? The objective or the principle behind this maxim is that it is based upon the competence of the decision making capacity of a person at the time consent was given. So, at the time when the consent is given, whether the person was having the competence to make that decision. So, obviously a person below 7-year age who usually cannot give consent because of mental disability, or a person who is unsound mind, their consent is obviously not going to be of any use. So, the person who is giving the consent or where the maxim application takes place is a person who has the understanding or who has the ability to give the consent. Now, this maxim has used in several aspects in legal field. One of the area where this maxim has been used is healthcare. When operation takes place, there is a consent form that the hospital requires the patients to sign. And this consent form says that the patient is consenting, knowing very well that operation is always dangerous. There can be some inadvertent consequences which may also lead to death of the person, but still, because this is for the only way the treatment could be proceeded. So, that consent form, but whether the consent form is a complete waiver or it is a conditional waiver is something that has come to question before court. So, in English law, in the case of Sideway versus Bethlehem Royal Hospital 1985, the English courts have said that this informed consent does not recognize this doctrine of informed consent, and the test of liability in respect of doctor's duty to warn his patient of the risk is inherent to treatment recommended by him. So, what the court is saying is that we accept that you have taken a waiver or you have a consent form before the operation you conducted. However, was the patient informed in real sense? Were he aware of all the risk that was involved with this operation? If he is a person of a tender age, or if he has other health conditions which may put him to higher risk for him, have you explained it? If those has not been explained, then this waiver or consent form cannot safeguard the doctor or the hospital. So, there has to be an explanation of the risk involved in the hospital to the patient by the doctor or the hospital in a proper manner, and then after that when consent is given, then it is acceptable. Same in position of India, a doctor has to seek and secure the consent of the patient before commencing a treatment. The consent so obtained should be real and valid, which means that the patient should have the capacity and competence to consent. His consent should be voluntary and his consent should be on the basis of adequate information. Now, with the euthanasia debate, this consent has become an important aspect. Now, when a person is in a pure vegetative state, now it is obviously understood in medical science that he cannot be recovered. His family members are willing to give the consent that you can withdraw him or withdraw the medical support from him, and he will have an automatic course of death. But that person is not in a state of giving consent. Now, when that person is not in a state of giving consent, unless and until there is a medical board created, appropriate all legal action is taken, withdrawal of medical support will not save the hospital, and it will not fall within the category of euthanasia or assisted death, but it will come within the category of murder. So, in Samira Kohli versus Prabha Manchanda in 2008, the courts have observed, the Supreme Court has observed that adequate information, what is this adequate information or consent? taken on the basis of adequate information. What this adequate information means? Now, adequate information means the doctor should disclose A, nature and the procedure of the treatment and its purpose, benefit and effect. B, alternatives if any available. C, an outline of substantial risk. D, adverse consequences of refusing the treatment. Now, if there is a scenario where a person at one side has to undergo surgery, on other side he has to undergo some kind of a supportive treatment. Now, if he undergoes surgery, there is a 70% possibility that he will recover, and he will recover fairly fast. In the supportive treatment, he will recover, but he will recover fairly slowly. So, but in the surgery, there is a 30% or 40% risk that he may go into purely vegetative state, or there may be some other problems. But in supportive treatment, all those risks are not there. If he does not recover also, there will be no damage, other damage to his health or condition. Now, then with all this information, then the person can make a choice as to whether he will go for surgery or he will go for supportive treatment. Now, unless this is made, only by signing a consent form saying that the person has consented, the patient or his or his scheme have consented, that is not enough. Right. So, the nature and extent of information to be furnished by the doctor to the patient to secure consent need not be the stringent and high degree, but should be extent which is accepted as a normal and proper, and this information should be normal and proper. Now, it is not that somebody has got a very negative result in America due to the surgery, and that has happened, but the doctor did not disclose about it because he did not know. That is not a reason. What is possible is that in the available information in the scientific domain, if it is a matter of treatment, whether the doctor's advice was based on that normal and properly or not, that will be the test. Now, the application of the maxim has other limitations also. Now, these are some of the limitations where the maxim will not be accepted, not be applicable. Of course, the first is no consent. So, or consent when it is taken in an improper manner, or consent without appropriate information amounts to no consent. So, where there is no consent, consent defense or voluntary non-fit injury act cannot be applicable, because the defense is principally based on the objective of consent. So, if there is no consent, no application of the defense. Second, the maxim has no validity against an action based on breach of statutory duty. Now, if there is a breach of statutory duty and you say that they consented it, it is not going to be acceptable. For example, gambling is prohibited in India, and you have gambled and you have lost the money, and now the other person wants to recover that money, and the court denies that there is no legal provision because gambling is banned. You cannot say he consented, he knew. This is not possible. Right. So, when there is no validity against an action, the maxim has no validity against an action based on breach of statutory duty. Right. Third, rescue cases. Now, in rescue cases, the maxim will not apply. So, if a person is drowning in the sea and a lifeguard goes and saves him, and in that process the lifeguards die. Now, the lifeguard family claims claims compensation, and the drowning man who was saved, now he says that he consented. He knew the risk that if you are going to go in the middle of the sea to save someone, though for a noble purpose, there is always a risk to your life. He incurred it. Now, law does not permit that, because that is not possible. Here somebody is doing something in good purpose with a good faith. So, if you instead of rewarding it, punish it, nobody will take then good actions. Then the society will not be able to support good actions. So, therefore, in any type of rescue cases, this maxim does not apply. Fourth, generally the maxim does not apply in cases of negligence. Now, when you have negligence on your part, you cannot say that the other person has given consent. Now, all these medical cases will fall in that regard. The medical cases will fall in the category of if there is a negligence on the part of the doctor to inform well or appropriate information based consent, then only a consent waiver is not enough, because it is your duty to help them to understand. Fifth, the maxim does not apply where the act of the plaintiff is relied upon to establish the defence under the maxim is the very act which the defendant was under the duty to prevent. So, the maxim is not applicable where the act of the plaintiff relied upon establishes the defence under the maxim is the very act which the defendant was under the duty to prevent. So, if the defendant is under the duty to prevent that very act, now if the plaintiff has relied upon to establish his defence, establish on that act that this is the wrong, then that cannot be the ground to take this defence of voluntary non-fit injuria. And the last one is the maxim will also not apply when the act relied upon is done because of the psychological condition which the defendant's breach of duty had induced. So, again, inappropriate consent, the person has unsound mind. In a case of voluntary involuntary intoxicated person, now this in cases where these maxims will not apply. Now, just to help you to understand better, I am giving two problems and trying to elaborate the application of the maxim or the non-application of the maxim in these two types of factual scenarios. In the first scenario, the facts are the plaintiff, a police constable, was on duty inside a police station in a street in which were a large number of people including children. Seeing the defendant's runaway horses with a van attached coming down the street, he rushed out and eventually stopped them, sustaining injuries in consequence, in respect of which he claimed damage. Now, can the defendant here plead voluntary non-fit injuria? Because ultimately the plaintiff willingly went to stop the carriage, and in that process he knew there is a risk and his injuries were was a direct consequence of such risk. No, here the maxim will not be applicable. Why? Because this is a rescue case. If we go to our previous chart, that rescue cases, the maxim does not apply where the plaintiff has under exigency. So, point number 3, exigency caused by the defendant's wrongful misconduct consciously and deliberately faced a risk even of death to rescue another from imminent danger of personal injury or death. So, this is a rescue case, hence the maxim will not apply. Second factual scenario, the plaintiff knowingly that the driver of the motor car was under the influence of drink and that consequently chances of accident were thereby increased, choose to travel by the car. She was injured in the accident caused by the drunkenness of the driver, in which the driver was killed. In an action against personal representative of the driver, the defendant raised the defence of voluntary non-fit injuria. Question is, will this case the court uphold or not apply the defence of voluntary non-fit injuria? It was held that except perhaps in extreme cases, the maxim did not apply to the tort of negligence and that the plaintiff was entitled to recover. Now, in this case also the maxim will not be applicable, because whether this was an extreme case or not, that will be based on the factual circumstances, to what state of drunkenness, whether it was apparent, whether he was not at all in a position fit to drive, yet the plaintiff chose to sit, whether there was other alternatives, still the plaintiff, and in what conditions the accident happened, was it completely the fault of the driver, was it because of his drunkenness. All these factors when lead to the consequence that it is largely because of the drunkenness factor which plaintiff knew very well and still incurred the risk, then otherwise in majority of the cases where the negligence of the driver is in question, the maxim will not apply. The maxim will be not applicable in such a case. Okay? So, this ends our discussion on voluntary non-fit injuria, and now we move to the second defence, which is plaintiff as a wrongdoer. Now, in this case, the principle is that a plaintiff suffers injury or damage due to some unlawful act or conduct of his own, which is connected with the harm suffered by him as part of the same transaction is disabled from recovering the reason of being himself a wrongdoer. Okay? So, you can say that when I am entering into a house where I know that there are dogs and it is clearly written that ferocious dogs are there and they can cause severe harm and injury, yet I choose to enter because I have some ulterior motives. And when I choose to enter, of course, when I enter I suffer dog bites and then I file a complaint. Now, in that case I will not be compensated because I am a wrongdoer here. My act itself is a wrong. The act of trespassing into somebody's property is itself a wrong. So, because I am a wrongdoer, so therefore I am therefore the defendant is exonerated. His act of his dogs biting me is exonerated on the ground that I myself was a wrongdoer, only when he has given appropriate notice in a space where it is possible for anyone to observe or know. Now, there is an illustration of this principle. A pillion passenger aged 18 years encouraged his friend aged 16 to drive recklessly and dangerously after both have been drinking together, and the motorbike met an accident in which the driver was killed and the pillion passenger suffered serious injury. The claim of the compensation was made by the pillion passenger against the representative of the deceased in negligence, which was negativated. Now, you see, of course, the maxim application in negligence cases is very limited, but this is a very limited case. Now, here what happens, two persons were in a motorbike, one was 16, one was 18. Now, first, a person of 16 years age has no license to drive. Secondly, you are not supposed to drive when you are in the state of alcohol, under the influence of alcohol. So, both of them were under the influence of alcohol. Now, the pillion rider continuously kept on provoking the driver that please drive fast, you can drive more faster, etc., etc. And in his encouragement the driver started driving fast, and in that process they made accident and the pillion rider was injured. It is immaterial the driver was alive or died or injured or not injured. But the pillion rider cannot claim compensation because he himself was part of the wrong. So, he was a wrongdoer. So, if he is a wrongdoer, he cannot claim a relief. However, not always wrongdoers, when even it is assumed that he is a wrongdoer, is ground to exonerate. This is a famous case in England decided quite some 1 century back, Bird versus Holbrook. Now, in this case what had happened is that the owner of a residential plot with some very small scale fruits orchard or something like that had placed in his garden spring guns, which are very, very dangerous, which can cause serious injury in adult and in children or aged people. It may even lead to death. So, he has placed spring guns to protect his orchard, and there was no notice also given to outsiders that there are these spring guns. Moreover, the spring guns were not operational only at a particular point of time like night time or something. It was 24 hours loaded and 24 hours it was in operational, and there was no clear direction or no clear message as to where it is placed. So, now a small child had crossed the wall and entered into the plaintiff's land to catch a stray fowl. Now, after he landed into the plaintiff's land, unfortunately he stepped on the spring gun and was very, very seriously injured, almost died. Now, in the case of compensation, plaintiff pleaded, the defendant pleaded plaintiff is a wrongdoer because he attempted because his presence is a trespass. But the court said, okay, even if we accept that the plaintiff is a wrongdoer, there is always a case of proportionality. Is your action of protecting orchard by placing spring gun which is inherently dangerous. So, protecting your property like that, what you can do? You can put some barbed wire, you can put some nails or glasses on your boundary wall, even to that extent you can keep a dog. But if you keep hounds, bloodhounds in your garden, or if you put spring gun, or if you put electrified wire, which in all possibility will cause harm, then is it proportional? Now, if the wrong and the damage is not proportional, then there is no question of pleading the defense will not be successful. Okay. Now, moving forward, the next case is inevitable accident. Now, what inevitable accident means? Inevitable accidents mean that where an accident could not be possibly prevented by exercise of ordinary care, caution or skill. So, an act has happened which has led to some kind of a damage or some kind of a injury and loss leading to the plaintiff. But if the cause of the act is such that it could not be controlled, prevented or care or cautioned with ordinary skill or care of a person, then it is falling within the category of inevitable accident. Now, there is an illustration and then there is a case reference. I will come to the case reference. Before that, let me go to discuss the illustration. Now, in this case, a man carries firearms or drives a horse. His duty is merely to use reasonable care not to do harm to others thereby. If notwithstanding use of such care an accident happens, he may plead that it was due to inevitable accident. Now, if a man is carrying a firearm or driving a horse cart or a motor vehicle, now he is supposed to take some due caution and care. Now, all the due reasonable caution and care if he has taken, after that, if due to something which is outside or beyond his control an accident happens or a act resulting into the injury of the plaintiff, then in that case the defendant can be allowed to plead the defense of inevitable accident. Now, there are two important decisions that can be discussed in this regard. The first decision is in a case where the defendant was driving on a highway and he lit a cigarette and threw the matchstick outside. Now, the highway and the place where the plaintiff's farm was at least at the distance of 1 kilometer. But unfortunately, on that day a strong wind was blowing which was taking things from the highway towards the plaintiff farm, and this matchstick, which was not completely alight, was flown on the air, and 1 kilometer distance away it fell on the defendant on the plaintiff's pile of hay that he had accumulated in his farm, and the hay was immediately set on fire and the fire broke out. His entire or portion of farm was damaged. Now, in that process, when the plaintiff claimed compensation, the court said that this is an inevitable accident, because it is not possible for a person who is 1 kilometer away, one farmland, some hay, to presume that his act of throwing a matchstick, which may not be also not properly lit or alight, to take care to presume that it will go. Of course, throwing a matchstick not properly alight is not appropriate, but still there is a reasonable presumption, and this is beyond the reasonable presumption. The second case is Farden versus Harcourt Revington. Now, in this case what had happened is that the defendant had kept his vehicle with 4 windows locked on the side of the road, parked it, and inside the vehicle he left his dog. Now, usually the dog is known to be a calm dog, and it was not the first time that he has left the dog inside the vehicle with windows closed and parked and left for some work. It was quite a regular business, and the dog had never caused any trouble or any problem. But that day there was few young children who were standing on the other side of the road, and they saw this dog inside the vehicle and they started throwing stones towards the car, and the dog got irritated and started jumping and shouting inside the vehicle. In this motion of jumping and shouting and whatever movements that he made, a small portion of the windshield got broke and it flew in a projectile motion on an other side in a tangential direction to hit the plaintiff who was standing at least 25 to 30 meters away from the car, and that went and hit in the right eye of the plaintiff, and the plaintiff was suffered a serious eye injury because of that. Now, when the plaintiff claimed compensation, the court said that, see, this is an inevitable accident because it is not possible for a person to guard against possibilities which are fantastic by its origin. This is not a reasonable possibility, it is a fantastic probability. So, you can guard against reasonable possibilities, but cannot take guard against fantastic probabilities. I will quote from the portion of the judgment of Lord Dandin, where he says, this is such an extremely unlikely event that I do not think any reasonable man could convicted of negligence if he did not take into account the possibilities of such an occurrence and provide against it either by not leaving the dog in the car or by tying it up so that it could not reach the window. So, people must guard against reasonable probabilities, but they are not bound against fantastic possibilities. So, this is a very important aspect. Later on it has become a part and parcel of the law on foreseeability. Now, this is something that you cannot guard against those fantastic possibilities. You can guard against reasonable probabilities. Now, moving to another category of inevitable accident, which is act of God, because here also the act is not something that has happened due to somebody's lack of care and caution, but it has happened because of some unnatural event. Now, in the first case, inevitable accident, it is not an unnatural event which is involved. In the act of God, there is an unnatural event involved. So, it means, as is explained, inevitable accident may be divided into two classes: those which are occasioned by elementary forces of nature unconnected with the agency of man or other causes of the term act of God is applicable to this class of inevitable accident. So, act of God is also a class of inevitable accident, but here the inevitable accident is not directly associated with the human agency. It is pertaining to some event which is outside the phenomena or control of human agency, like rain, flood, earthquake, cyclone. So, they are called act of God. Now, in a very famous case, this defense was discussed in thorough manner and ultimately the defense was not allowed. Now, in this case, what had happened is that the defendant got lease of a land, quite a big volume of land, to develop it into an amusement park with reference to water. So, water amusement park, today it is very common, we have so many water amusement parks. So, this defendant was developing a water amusement park. In that process, in order to secure flow of water into its land, it changed the course of a stream which was flowing just beside the land. So, there was a natural spring which was flowing just beside the land. So, it through artificial way, it diverted the stream from its natural course to a part of it entering its land, so that it gets a flow of water. Now, this was something which was objected, but they said that it is not going to cause any harm or damage to anybody, it is part of the natural process. Though it is artificially entered, but there is nothing to worry about. But unfortunate to the defendant, there was a downpour of a unimaginable nature that year. So, the unimaginable nature of downpour and the rain caused severe flood, overflowing of the river, and because of the change in the natural course of the river, now the water of the river overpoured on the other side, which was belonging to the plaintiff, who was a railway company. and his rails got flooded, damaged and severe loss caused to them. Now they filed a case against the plaintiff for compensation, and the plaintiff piled up the defense against them that it was an act of God. This rain, in normal course this could not happen, but because of this uncontrollable event which is not in hand of human agency, the overpouring of the rainwater and the subsequent flood, this happened. Now here the court said we would have accepted it if it was part of the natural course of the process. But your human intervention to get the water into your water amusement park by changing the natural course of the water breaks a transaction. So there is a break in the transaction, and this break of the transaction now no more leaves it just a complete inevitable accident or an act of God. Human intervention is there, and hence the action for damage is allowed. So the plaintiff having brought an action against the defendant for damage, the jury found that there was no negligence in the maintenance of the construction of the pool, and that the flood was so great that it was reasonable to be anticipated, though it had been anticipated in the effect might have been prevented. So, but adjacent to that there was another case, which is the case of Nicholas. The one that I discussed is not Nicholas versus Marshland, it was case before Nicholas versus Marshland, where inevitable accident defense was not allowed. But in Nicholas versus Marshland, where that case was also cited, inevitable accident was allowed, because the only difference between the two factual situation of the case was that in Nicholas versus Marshland there was no use of human intervention. So there was no diversion or there was no change. What was that? That these banks were there, and the banks were not able to contain the water because of the overpower or overflow of the rain. Hence the inevitable accident defense in Nicholas versus Marshland was granted. Now moving to the next defense, which is private defense. Now I told you at the very beginning that everybody has a right in this world to protect their life and their property. So when it comes to life and property, protection for that action taken is justified. So right against private defense is exactly that when somebody attacks you, you have a right to defend you, and in your defense, if you cause harm to somebody, that is justified. Similarly, if somebody causes harm to your property, if you are trying to defend yourself, that falls within the right of private defense. So private defense therefore means when a man strikes to another within a distance capable of later being struck, nature prompts the party struck to resist it, and is justified in using such a degree of force as will prevent the repetition. So when somebody is threateningly approaching towards me with a fist, and in all possibility he is going to hit me, it is very natural that I will try to first defend myself and then send a punch to him. Now in case if his punch misses me and my punch hits him and causes injury to him, I will be defended, because I was not the first to instigate, I was the defender. So I am defending my body. This is right to private defense. Now illustration, a landowner on his land, there is a sudden accumulation of water brought there without any fault or act of his, is not at liberty actively to let it off on the land of the neighbourer without making the neighbour as compensation for the damage, because the landowner by doing so has able to save his property from the injury. So if in my land due to heavy rainfall water comes, then I can open some channel to let the water go. Now in that process, if my neighbour's land is somewhat damaged within a reasonable proportionality of the loss or damage that I tried to prevent, then it is falling within the category of right to private defense. However, in private defense proportionality is very important. If somebody is approaching with a fist, I cannot shoot him with a gun, or I cannot hit him with a sword, or even I cannot hit him with a stick. What maximum I can do is that I can defend myself, I can put a fist, I can put a slap, but or I can push him on the other side. But if I take a sword and hit him, then that is not falling within the category of private defense, because the threat and my act has to be proportional. Now, if the threat and my act is not proportional, then it is not coming within the scope of private defense, right. Now, in Bard versus Holbrook, the case we discussed earlier with plaintiff as a wrongdoer, private defense was pleaded by the defendant that the spring guns were put in his land to protect his land. So, protecting his property. However, the court held, is it proportional? Now, to defend your property of a nature which is not something very extremely valuable, things are there, or for strategic reasons, for statutory grounds, it requires to be completely specially sealed or defended. Putting spring gun, is it reasonable and proportional? If you had pulled some nails on the wall, boundary wall, it would have done. If you had put barbed wires, it would have done. Even if you had pulled the spring guns, but 24 hours keeping it open, it is not definitely justified as a proportional act. So, if in right of private defense, when it is proportional, some party is affected because of it, then that innocent third party from the act done in self defense is called an accidental harm. It is an accidental harm, and accidental harm is not lawful, not an unlawful act. Now, the next defense is necessity. Necessity means small damages caused to prevent greater harm. Now, necessity can be of two types: private necessity, public necessity. Now, let us discuss first the public necessity. Now, where welfare of the people is the supreme reason. Now, say for example, as I said, there are 20 buildings at a row houses made of thatch and bamboo. Now, fire breaks on the first and it is engulfed. The second one is also engulfed. When the defendant notices, what they do is that they go and break the fourth house, because the third house by that time has already started burning and it was not possible to prevent it, but they break the fourth house. Now, because the fourth house was broken, now the fire could not reach the fourth or the fifth or the sixth or in a progressive manner. So, in that process, by breaking down the fourth house, what it saved is house number 5 to house number 20. So, in a process 16 houses were saved. Now, 3 houses obviously were burned by the fire. So, there is no way the defendant is liable for that. The defendant's liability is with the single house, which is the fourth house, which it broke down. Now, can the defendant be held liable? No, because this was a minimum act which was necessarily done to prevent a larger wrong or larger loss to 15 houses, and hence it is protected. Similarly, private necessity may require some defenses of necessity. So, for example, an illustration can be given: pavement dwellers are occupying pavements through sheer helplessness. So, when comes that, are they committing tort of trespass? For example, in our country it is common that pavements which are built are occupied by the homeless people. We see often these people building shelters below flyovers, railway stations. Now, are they to be put under trespass law of tort? No. Why? Because necessity. So, helplessness, and this was upheld by the Supreme Court in Olega Teli's case. So, therefore, as I already said, that if fire is breaking, and if you do that, it is an example that has been given in my slide with reference to necessity. And the last one of the defenses is mistake. What does this mean? A wrongful act caused due to lack of awareness or inadvertent mistake. Now, mistake can be of law, mistake can be of fact. Now, mistake of law is not a justification. Ignorantia juris not an excuse. Now, if you go and do 2 marriages and your second marriage is illegal because law prevents second marriage, and you say I did not know, that will not help you. because ignorantia juris is not excused. However, sometimes factual ignorance can be excused. For example, you go and put a fancy plat to your friend, to a person B. When B turns, you understand that whom you are thinking as your friend, he is not exactly that person. Now, can you be held liable for battery? No, because it was a mistake of fact. So, a joking pat or something like that, it is a mistake of fact, and mistake of fact in such cases can be allowed as a bona fide defense when there is a bona fide nature of the mistake. Okay. So, therefore, I sum up the discussion. These are the major defenses which are generally applicable to almost all torts. I have discussed. These are called general defenses. In addition, there are some specific defenses which I will discuss with reference to each individual torts when I take it up in my subsequent lectures. So, defenses are important because defenses makes sometime your wrongful act excused. So, that is why knowledge of defenses is important, because the defendant, when in his reply to the plaintiff's case, pleads defenses for exoneration. So, thank you very much for being a patient listener, and hope to see you in my further classes. Thank you.